Just by way of introduction, I'm Mark Hawes. I'm head of the corporate practice and a partner in the law firm Bristows LLP, which is a City of London law firm, probably best known for its work in technology and intellectual property-based industries. And we act for multinational companies, medium-sized companies, and also for startup companies. And so it's a matter of great interest for us to be here today. I've been a lawyer, I think it says in the pack, for over 25 years, and I'm sort of sticking at that figure, but it's creeping up to 30, but there comes a point where it makes you sound really old, so I'll keep it down for a while. The work I do is principally advising businesses on mergers and acquisitions, on setting up business in the first place, and on raising finance. And so I advise large companies on those sort of transactions, but also small startup companies. And I'm accompanied here today by Adrian Sim, who will tell you a bit about himself later, and Adrian's a senior associate in the firm. We're going to tell you about some of the practical issues that we think you'll encounter in setting up a startup business. I'll be focusing on corporate issues like shares and promoting your company to potential investors, a bit about directors' duties, those scary things, and also on useful information such as tax reliefs on investment, which is a way of attracting investment in the first place. Adrian will be talking about the sort of contracts that you may need to put in place or deal with in setting up a business and developing a business. And he'll also focus on what is probably one of your most important assets, which is your intellectual property. And Adrian will describe how you identify it in the first place, how you protect it, and how you commercialize it. As with the other sessions, but more so in this case, we'll take questions at the end, if we may, before lunch, and we can also take questions over lunch because we'll remain for that session. So, I'm starting on the premise that if you have a startup business, you've chosen to put it into the shape of an English private limited liability company. I'm assuming also that you're a fully for-profit, a commercial business. We can talk later, if there's time, about social enterprises, which is one of those buzzwords that covers all sorts of entities nowadays, from charities to part for-profit, part profit, fully for-profit companies. But I'm looking at the commercial enterprise in the shape of a private limited liability company. Why is it called private? Well, legally that means it can't offer its shares to the public, unlike a PLC, a public limited company. And by the way, there tends to be a misunderstanding that PLCs are all stock exchange listed, but if you're encountering a PLC, it's probably not stock exchange listed. Most aren't. You don't have to be stock exchange listed to be a PLC, although the reverse is the case. And private companies enjoy much lighter regulation than PLCs. So if you've set up a private company, the law is trying to make it as easy as possible to administer your company. You have, as a company, separate legal identity, so you can enter into contracts in the name of the company rather than personally. And of course, the magic of being a company is it has limited liability. And what do we mean by that? Well, we mean that creditors don't have access to your personal assets as a general rule. If the company fails, they can only go against the assets of the company. And indeed, shareholders' liability is limited only to the amount that they agree to pay up to the company for shares in the first place. But there are, unfortunately, exceptions if you're setting up a business, in that if you're dealing with a bank lending you money, or if you're dealing with a landlord of premises, those sort of entities don't want to take the risk on your startup business, and they'll look through it and look to you, probably, for personal guarantees. So liability limited by the private limited liability company is extremely useful, but in reality, you may have your own neck on the line to banks and landlords and the like. How do you get started? Well, it sounds like a lot of you have already done this. You've probably gone to a company formation agent, or you might have gone through a solicitor or an accountant. You'll know that in setting up initially that you have to be careful on the choice of the name of the company, and that's the case if you want to change it as well. You have to watch out for this long list of so-called sensitive words that may need special permission. So it's not necessarily straightforward to call yourself X International Limited, or to call yourself an institution and various things like that. So you may need special consent for your name. You hear the terms bandied around, memorandum and articles of association. It used to be that the memorandum was quite an important document in the ongoing life of a company, and you'll hear a lot of people still refer to it. In actual fact, the memorandum now is a bit of a technicality, and what you should really concentrate on is your articles of association. That's your constitution. It sets out the internal mechanics and management procedures for the company. And when you set up a company, typically you will get a model form of constitution. Right at the very start, you're probably not creating some sort of tailor-made constitution. However, when you take on board external investors, that's when it can start getting complicated. And external investors may want special provisions put into your constitution, and they may also want a separate document, a shareholders' agreement, that overlays the Articles of Association. And one point to realise is Articles of Association are a matter of public record at Companies House, but shareholders' agreements, where you actually get into some of the detail about how the company is going to be managed and controlled and financed, if that's in a shareholders' agreement, as a general rule, that's a private document. It's not filed at Companies House. You'll know that you, as a private company, are subject to a raft of Companies Act requirements to maintain all sorts of registers of members and shareholders and share transfers and so forth. And you do have to keep those up to date. In due course, if you seek external investment, people will do due diligence on you, and they will look at those books. And all too often, it's a temptation to procrastinate and not keep them in order, and that can look unprofessional. You'll need a registered office, not necessarily where you carry on business. You may need to pay for some company to provide that. Of course, you'll have directors, and if you're a founder, you're likely to be a director. As a private company, you don't actually need to have a company secretary. Nevertheless, someone's got to do the dog's body work of keeping those registers up to date. So it's sensible to assign that role to somebody, even if formally you haven't appointed somebody with that name. Also, and this is important, although it seems sort of boring and painstaking, there are all sorts of disclosure obligations. You've got to put full particulars about your company, its registered office and so forth, on your letterhead. You've also got to put it on your website. And there we have a mock-up of a company called YOLO Holidays, all the usual stuff that you'd expect to see there on a website. But if we home in at the bottom, there are these particulars: the full name of the company, i.e. the bit with limited at the end of it, the registered in England fact, the registered number, and the registered office. And I suggest if you have a look at a lot of websites from companies, even quite well-known companies, they failed to put these particulars on their website. And you might think, well, why does it matter? I think it can matter in particular for a startup business, because it's very important to present to the world as a company. A company is required to put these particulars on its website, also on its email footers as well. So if you've got those equivalent details for your company on your website and on your letterhead, at least you'll be complying with companies law and unambiguously presenting yourself as a company, rather than potentially as an individual trading as YOLO Holidays, which would risk your not having the benefit of that limited liability. So from what can appear slightly sort of boring technicality, cumulatively, if you're not presenting as a company, there are risks. As you know, you're subject to this vast regime of filings with Companies House. I've put on this slide, and I think you'll get access to a hard copy, a link to one of Companies House's best publications, I think, that just takes you through all the annual filing requirements. Filing can normally be done online. Most important filings, of course, your annual accounts, also the annual return, which is this snapshot of information on share capital and directors and so forth once a year. And then during the year, you must remember, if you do things like change your directors or change your registered office or issue shares, then you've got to file as well. You should keep that public record up to date. Again, if you're looking for external investment, external investors will be looking at your competence in keeping these sort of records fully up to date. And also, when you are dealing with companies in business life, it's always a good idea to do a company search on them. All this information goes on the public record, as a general rule, and so you can look up the accounts of companies you're dealing with. All companies must keep internal accounting records. They've got to keep them for 3 years, and all companies must prepare accounts. Profit and loss account, balance sheet, and notes to the accounts. If you're a startup company, the likelihood is that you're going to qualify for the small company exemption from audit, so you're not likely to need auditors. But as I think an earlier speaker was saying, you may be able to do this yourself. I wouldn't be able to. I'd shy away from it. So there's no legal requirement to have an accountant, but common sense dictates that you probably do need someone who is competent with the numbers. It is essential to file your accounts on time every year, and there's the general rule that you must file them within 9 months at the end of your financial period, your financial year. If you don't file on time, the company automatically gets a civil penalty of £100, and that rises over time the longer the delay in filing. And also, directors commit a criminal offence, potentially liable to £5,000 for each offence, potentially liable in extreme cases to disqualification from serving as a director of an English company. Now, if you're late, in a minor way, that's not going to happen. There'll be the automatic fine on the company. But for sustained delay, or if you're delaying and breaching the requirements across a number of companies, then you might need to worry. So it's important to be systematic about filing accounts online. Again, thinking from the perspective of a potential investor who's doing due diligence on you, it doesn't look good if you are late filing with your accounts. Also, in doing business with people, they may do company searches on you, and if your accounts are late, that immediately raises a question as to your, at the very least, your competence, but it may raise a question as to whether there's some problem in filing the accounts, that your company's in trouble. So you want to avoid that suspicion. If you're raising finance, you'll be looking at alternatives of raising finance by debt or by way of issuing shares, so-called equity share capital. And just thinking of debt from the first principles, typically a bank lender, if that's where you go, is going to require security over the company's assets. But as I mentioned earlier, that bank may also want a personal guarantee from you, and the bank might want security from you personally over your assets as well. At the end of the day, if a company's wound up, debt gets paid back first. So debt always ranks ahead of share capital on a winding up. Usually, though, a bank isn't entitled to some sort of upside. If a company is very successful, a bank just gets its capital back and the interest payments that you've agreed to pay. There can be exceptions. Debt can be fashioned in all sorts of ways, and you can have debt that can convert into shares that would benefit in the success of a company. You're likely to be looking at issuing shares to external investors, and shares come in all shapes and sizes, listed quite a few of them there. All companies will have ordinary shares, which give a right to vote at general meetings and participate in dividends and in returns of capital, which is to say, if you wind up in the surplus assets, you can get those out. Investors will very often wish to invest on preferential terms. They will very often want preference shares, which give them preferential rights to returns of capital, preferential rights, first dibs on any dividends that are payable by the company. Against that, they might have fairly limited voting rights. You, at an early stage in a startup, are often looking at all sorts of investors. You might be looking at family, friends, potential venture capitalists. And in my experience, one of the problems that can be encountered is that enthusiastic founders can slightly, as I put it here, overpromise their share capital. They can say, oh, I'll give you 5%, give someone else 10%, without really knowing what they mean and the implications of that. And that can lead to problems, particularly if it's been reduced to writing, it's been put in emails. You can get your share capital in a real pickle, and that could prejudice getting in serious amounts of money further down the line if the company, and especially if the company is successful, because that's when everybody is interested in asserting rights in the share capital. So if an investor comes along and finds that actually you've written all sorts of sort of half-baked promises of percentages of share capital, or offered a share option to your auntie, that sort of thing, and obviously I'm exaggerating, but one sees sort of incidents of this sort of behavior where the share capital is overcomplicated and overpromised in the early stages. So try to keep it simple and be very circumspect in what you say about offering share capital to people. This next slide addresses one of the restrictions of law under the Financial Services and Markets Act concerning promoting your shares to investors. The general point is here that the law protects those who are encouraged to invest in shares, and it makes common sense that investors should be particularly protected against high-risk startup companies. Under this law, it's a criminal offence for a person who isn't authorised under this legislation to communicate a financial promotion in certain circumstances. And a financial promotion, here the term is defined, is any invitation or inducement to people to subscribe to your shares, basically, in this context. So financial promotion is very broadly defined, and it can cover oral statements, some sort of formal investment presentation, and it can cover written statements, so information memoranda or business plans that you're pumping out in order to induce someone to invest in shares. So it is, as a general proposition, a criminal offence to issue one of those unless it falls within one of the statutory exemptions, which I'll mention in a moment, or you get someone who's duly authorised by the Financial Conduct Authority, a successor to the Financial Services Authority. If you get such an authorised person formally to approve your business plan or investor presentation. Now, obviously, for a startup, you don't want to get into that territory, because an authorised person would be someone such as a corporate finance advisor. It's going to cost money. In all likelihood, you're going to prefer to fall within one of these statutory exemptions. And broadly speaking, if you are promoting shares, you're encouraging investment in your company by an investment professional or a sophisticated investor, someone who's accustomed and demonstrably accustomed to taking risks in investments, or if you're dealing with the term is precise, a certified high net worth individual, someone who can certify that he or she has in the last year had an income of something like £100,000 and free assets of £250,000. Well, these sort of categories of people, you can, with compunction, promote your shares. The problem is that if you are encouraging someone to invest in your shares who just happens to be, quite rich, has some spare cash, is an individual, isn't an investment professional, well, that person is exactly what the law is trying to protect. Unfortunately, in practice, that might be exactly the sort of person you're talking to invest in your company. And there's no perfect solution there. It may be that you just have to be very cautious in precisely how you go about encouraging investment. And in particular, I would say that because, as mentioned at the bottom of this slide, there are other laws, not just those concerning financial promotions. There are other laws that bite on your making misleading statements in connection with selling shares. It is probably a good idea to take legal advice. It needn't necessarily cost the world. It may be just some limited advice on checking out how you're going about marketing your shares and checking out the status of the person to whom you're promoting your shares. So, general message there is take care when marketing shares to potential investors. Just as a sort of interesting aside, I note that there is now this sort of phenomenon that's arrived in the UK of crowdfunding, which is to say the collection of cash for a business on the basis of very small contributions, perhaps £1 per person, from a multiplicity of contributors who are attracted through some internet platform, some website, which will, for your particular project or your particular business, say that it's seeking to raise, say, £100,000, and everyone who reads the website is invited to contribute £1. And rather than getting shares in return, or rather than lending that money, you might get some goods, or you might get some T-shirt, or you might get some letter of thanks from someone famous. And because it's only £1, you might be quite tempted just to do that for a laugh. And the cumulative effect of that might be quite significant. And the good thing about that for a company is you actually haven't given away any shares. And I've mentioned here a couple of internet platforms. There's the Kickstarter platform, which raises money on an all or nothing, A-O-N basis, which is to say it sets a target for funding, and unless that target is met, it's only if the target is met that your money is kept. And then there's the obverse of that. There's the keep it all basis of funding, where you can promote a company or promote a product, and whether or not you hit your target, you get to keep whatever anybody has decided to contribute. There is now, though, also an organisation, Seeders, that runs one of these crowdfunding websites, which is actually effectively flogging shares or debt in a company. But I think there are probably a number of issues to be considered there about going down that route. I would imagine that normally, if a startup is seeking investment by way of shares, that you really want to be in control of that process. You don't want to be handing it over to some website. When can your company pay you dividends? Looking ahead to the positive times where your business is actually successful, always bear in mind that you can't just extract dividends because there's some spare cash in the company. Dividends are only payable as a matter of law and accounting out of the distributable profits of a company, which are its accumulated realized profits less its accumulated realized losses, which put simply means that over time you must have gone net into the black, net into profit. Even if you do reach that happy position where you've got some distributable profits that could be paid out to shareholders, if you've got in external investors, as I mentioned earlier, they may have negotiated preferential rights to return of those dividends, so they may get the first bite on them. And generally, if you've taken on external investors, you may have had a thought about what would happen when you get into profit, and you may have a dividend policy, which is to say you determine that actually you won't pay out all the profits, even if as a matter of law and accounting they could be paid out. You might decide to retain them in the business. I mentioned earlier directors' duties, these frightening things, and a lot of ink is spilt on this topic. It is important to be aware of those duties, and I would urge you to look at the relevant provisions of the Companies Act and relevant, say, web guidance on the point. I've just isolated 3 of the duties here. The general one, which is it's your duty as a director of a startup company or any company to promote that company for the success of its members as a whole. So obviously you shouldn't be taking every investment decision or business decision with a view to furthering your own interests. And there is also this requirement to declare personal interests in transactions and to avoid conflicts of interest. And I mention those because when people set up startup businesses, often they're juggling a number of business initiatives. They might have 1 or 2 startups, or they might have interests in other businesses, not ownership business interests necessarily, but some sort of interests that potentially conflict with the business of the startup. It's a fact of life that you encounter conflicts of interest, and as a general rule, there are ways to navigate around them. But the important thing is to disclose them, and this is going to be more of an issue, obviously, when you've got in external investors in, where you must be faithful to the interests of your company. In running a company, you should hold regular board meetings. You should keep records of those meetings. That's another area where things can fall down, and it's all important because there are liabilities attaching to breaching duties to a company. And there are liabilities to shareholders and third parties in extreme circumstances. And there are numerous liabilities that directors can incur for breaching statutes. So it's all this sort of frightening raft of legislation. Some directors, I think, well, if I get fined, surely I can just call on the company to reimburse me. And that is an unsafe assumption, that is not necessarily the case. As a matter of law, a company can indemnify a director against third-party liabilities, including the legal costs of fighting them, which can be half the problem. But a company can't indemnify a director if the director has breached duties to that company, nor if the director has incurred criminal fines. The partial and important solution here is to consider directors' and officers' liability insurance, which is going to provide a good degree of comfort for you. Like all insurance, it has its exceptions. So if you do suffer criminal fines or you're fraudulent, you can't expect to be protected by an insurance policy. But it will provide a lot of comfort. It comes at a price, but it is common. And I think there will come a point in any business life where you'd want to take it out. One issue that I would mention in connection with directors' liabilities is that of wrongful trading. As we've heard a lot today, there is a risk of failure. It's, an entrepreneurial venture may fail, and the law recognizes that. But the law also looks at the behavior of directors that may have led to that failure. And if a company goes into insolvent liquidation, if your business fails and it's got debts outstanding, there will be an inquiry into the behavior of the directors. And this test I've put here is particularly important. If a director has allowed a company to carry on trading past the point where the director knew or ought to have concluded that there was no reasonable prospect of it avoiding going into insolvent liquidation, and that director didn't take every step with a view to minimizing loss to creditors, well, in those situations, there is a risk that a director will be held personally liable for the debts of the company. I think that's a really important take-home message. You're allowed to fail. It doesn't necessarily mean that you're liable personally in the event of failure. The company has limited liability. The basic position is that creditors, if they've been left owing money, can only get that money out of whatever is left in the company's pot, unless they've got at you with personal guarantees. But in this situation where there has been wrongful trading, a director can be held liable for the debts of the company, can be asked to contribute to the company's assets for the benefit of creditors. And if a director is held liable for wrongful trading, there's also a risk that that could lead to disqualification from serving as a director of an English company. So I think the take-home lesson here is don't bury your head in the sand. If the business is failing, it's important to consider whether to stop and when to stop. And sometimes that's a fine judgment, because it may be important just to wait for another contract to come through. That might be the sensible thing to do. But if you just sort of turn a blind eye to it and debts keep running up, that's when you might face personal liability. So an issue very much to be watched by startups in the early stages. Startups pay tax, must register for VAT if they hit the turnover threshold of £79,000, must register for PAYE and NIC. Not going to go into that. Once you're profitable, in the eyes of the taxman, you pay corporation tax. For a small company, there's a small profits rate of 20% corporation tax on profits below £300,000. And there are also various corporation tax reliefs. So I think Adrian's going to mention a couple of those. On a positive note, I want to mention this tax relief for investors that's particularly useful for startup companies. And that's under the Seed Enterprise Investment Scheme, SEIS. In simple terms, if an investor invests money in a company, an amount equivalent to 50% of that can be lopped off the investor's tax bill. It's quite a good break. And furthermore, an investor getting shares by way of that investment can later sell those shares exempt from capital gains tax. Now, unsurprisingly, this is all subject to restrictions. There's an annual investment limit for an investor of 100,000. He can't own over 30% of the company, and he can't be an employee, although he or she can be a director. So a founder could benefit as a director from this quite generous tax relief. There's also the requirement to hold shares for over 3 years. And there are also qualifying conditions for the company itself. And perhaps disappointingly, a company can't raise over £150,000 over the period that this scheme is operating, which I think was said was till 2017. It can't raise more than £150,000 there. But still, if you're looking to an external investor, just bear in mind there is this quite handsome tax relief for that investor in your startup. And also there are other schemes, the Enterprise Investment Scheme, which offers an equivalent 30% income tax break for investors in companies. But I think it's the seed scheme that you should bear in mind for the smaller startup business. And finally, on a positive note, there are other tax advantages in connection with startups. There's the Enterprise Management Incentive Scheme, which is a scheme that allows for tax-advantaged share options in a startup. And also looking to the happy day where your business might be sold and there's a huge gain, there is what they call entrepreneurs relief, which reduces capital gains tax on a sale of a startup's shares from the normal rate of 28% to 10%. And the conditions there aren't too difficult to satisfy. You must, as a seller who's seeking to take advantage of this entrepreneur's relief, hold more than 5% of the share capital and have been an employee or director, so founder, tick. The company must be trading, and these facts must have been so for 12 months prior to the sale. And it can apply whether you're selling the shares in the startup or whether you're selling the business. So I wanted to end up my piece on that sort of happy note that 10% capital gains tax if you're selling your startup, the happy scenario. I'll now pass to Adrian to talk about contracts and IP and all of that. Thank you.
My name's Adrian Sim. I'm an associate at Bristows and I work with Mark. I'm a technology lawyer, so I deal with everything tech related, whether it's IP or IT transactions to helping businesses launch apps or launch an e-commerce platform to help their business operate online. Today, I'm going to touch on some sort of basic contractual issues that I think you'll probably come into contact with when you're starting your startup and also when you're running your business. And some of these issues are really important to think about right from the outset. But what I'm going to focus on is the topics or the area which I think is of the most value to your startup at the moment, which is intellectual property. A lot of startups, you don't have many other sort of tangible assets, but your intellectual property and your ideas and your concepts and how you put them in place is what's going to differentiate your business and what a lot of investors are going to be interested in. But first, just to take you back to the contracts. Everything and anything can form the basis of a contract, and you probably enter into them all the time without knowing, whether you're parking your car in a car park, buying something from an off license, surfing a website, or even just exchanging emails. All of these things can form the basis of a contract. And as an individual, maybe you don't worry about it so much, but as a startup, for a lot of the liability issues which Mark was alluding to, these things are really important because you want to know when you personally or your company is incurring liability that could come back to bite you later on. One thing there's a common sort of misconception that all contracts need to be in writing, which isn't true. They can be oral, they can be in writing, or you can even have a contract where there's nothing said or nothing written down by performance. So just the fact that you're doing something for someone else, it's possible that you're creating a contract between those two entities. There are several things that go into forming a contract. There needs to be an offer to do something. There needs to be acceptance of that. There needs to be an intention to create some type of legal relationship between the two parties. needs to be certain what you're doing, so there needs to be certainty of terms, and there needs to be some form of consideration, i.e. you need to be exchanging something valuable, or whether it's just a promise or there's some money changing hands, something like that. I'm only really going to focus on one of those things today because I think that it's particularly relevant for startups, which is the intention to create a legal relationship. Because obviously, if you say to your mates, let's meet at the pub, or I'm going to be at the pub at 5 o'clock this afternoon, that doesn't create any type of contractual obligation for you to do that, other than you might have to buy the first round when you get there if you're that late. But in a business context, it is important to make really clear whether or not you are intending it to be a contract, because as a startup, a lot of your sort of initial seed funding or getting help from people are going to be from your family and friends. And as a general principle, the law doesn't imply this intention to create a legal obligation in that sort of domestic or that family setting. And you may think this is not that important because it's just like a relationship I have with my mates, but I don't know, a lot of you have probably seen the movie The Social Network. Your friends can help you code, or your family can help you code or create things. And if you don't have a contract in place or an understanding as to how that's going to work, you may find that 5-10 years down the track when your business or your startup's really successful, that you don't actually own a lot of the intellectual property that went into your business at the start because someone else created it, even though you asked them to. I'll come on to that later on in terms of the relationship between, say, an employer and an employee creating something in the course of their job, and the difference between, say, asking someone like a contractor or a consultant to do the same. So it's just that's just one thing to bear in mind when you are sort of asking for help and not only looking for funding, but getting sort of tangible help from your friends and your family. Mark's already spoken about some of the sort of contractual pieces that you need to put into place, or the written documents you need to put into place when you're starting a company. But I'm going to look at more the types of things from a really practical sense that's going to help you drive your business at the back end, and also the types of agreements or arrangements that you need in place with the people, your customers and your consumers. So there are things at the front end and things at the back end, but they're going to be really different. So whether you're the next Amazon or eBay, your sort of contractual needs are going to be quite different to someone who's setting up a new social network or something like that. But there's a raft of sort of agreements or documents that you will need to consider if you're going to have any type of sort of online presence, which I think is going to apply to most of you here today. Generally, there are two purposes of a contract at a really high level. One's to ensure that you get what you're after, so making sure that your suppliers or people providing services to you are delivering what you need, but also to help protect you or to limit your liability to your members or your customers and things like that. I'm going to talk about this at a slightly higher level and with two particular issues that crop up a lot with startups and also with everyone who's working in an online setting. The first one relates to intellectual property and user-generated content. So if you're hosting a website and you decide to allow people to post things on there, you need to think not only about, is it appropriate what they're posting, but really from a liability point of view, is what they're putting up there going to put you into trouble with someone else? Because sort of counterintuitively, if you're asking people to generate content or post content on your website, my gut reaction would be, actually, if I sort of don't moderate it, or I don't sort of monitor what goes on, or I don't vet it, my responsibilities shouldn't exist. Whereas actually, the more moderation and the more sort of you look at things to say, oh look, this is inappropriate, I'm going to take it off, that can actually increase your liability. So you need to make a decision about the extent to which you're going to moderate. The other thing to think about, which is a really big issue these days, is privacy and data protection. So we talk about content and content being king and people being able to license it and put content on different platforms and monetize content in that way. But actually what I think is going to happen in the future is that individuals, your consumers, your customers, people that are members of your social network, their personal data and their privacy rights are really important. You see this to a certain extent because you get to opt in or opt out of receiving marketing emails when you join certain websites. But ultimately, because of advertising revenues, personal data and how you as a website operator or as a business collecting information about your customers or your consumers, how you do that and what you can do with that is potentially going to be a really big revenue stream for you. So you need to think about putting things in place like a privacy policy, because one of your obligations at law under the Data Protection Act is if you're taking information from individuals, you need to make it really clear to them, and they need to consent as to how you're doing that, why you're doing that, and other things like if you're going to send that overseas, if it goes out of the European Union, have you got certain measures in place to ensure that the country you're sending it to has adequate protections in place so people don't sort of have their personal data exploited. I'm going to flip now to intellectual property and talk about this for a few minutes, or this will sort of be the rest of the presentation. There are two quotes up on the board. The first one was from PwC, which talks about the value of intellectual property to companies. And in the same report, they estimated that for most listed companies around the world, more than half of their actual value is in what they call intangibles, which is intellectual property, the sort of ideas and concepts that they've formalised and tried to commercialise. And that's for listed companies. So for startups where actually you may not have a lot of tangible assets, your intellectual property is going to be the vast majority of the value of your company. And the second quote was from Mark Getty of Getty Images, who was quite prophetic when he said this, because if you look around the press these days, a lot of the big battles that you see and read about are related to IP. I mean, you can talk about Apple and Samsung and the sort of the patent wars that they're having at the moment. And we're talking about billions of dollars worth of disputes over, different types of technology that have patents or design rights over them. So it's a really, really fundamental part of your business. There's just a few types of intellectual property rights that are up on the board, and I'm not going to talk about all of them, but I will focus on the first three, which are probably the three that you're most likely to come into contact with. But at a really high level, intellectual property is a valuable right, but it's an intangible right. So it's not like a house in the sense that you can see it, you can feel it, you can touch it. But in other ways, it is quite similar because you can trade intellectual property, you can buy it, you can sell it, you can license or lease it. One thing that you do need to really bear in mind is that intellectual property rights, there are different types of them, and they're generated in different ways. So for example, copyright, which can be source code that someone's written or the words in a brochure that you've got. Copyright's generated at the point that you create it. You don't need to do anything else other than create the work which embodies the copyright. Whereas there are other types of intellectual property rights that really only come into existence once you've done something or taken an active step to register them. For example, patents and design rights and trademarks and things like that. So there is a distinction, and you need to be clear about that because you want to understand what intellectual property rights you've got and whether they're going to be protected. The other thing to bear in mind is that most intellectual property rights are territorial in nature, i.e. they only work in one jurisdiction unless you register them in different types of jurisdiction or in other places around the world. So you need to think about not only where your business is located, which for I'm assuming all of you is going to be in the UK, but also where your major markets are going to be. Because if you've got a particular brand that you want to protect and you think, actually, we're going to market really heavily in Asia, you may want to ensure that you've got trademarks registered in those jurisdictions so that if another company sets up with the same name or the same logo or symbol, you're going to be able to enforce your brand and protect your brand in those markets. The three that I'm going to talk about really briefly are just patents, copyright, and trademarks. Patents, broadly speaking, it's a protection on inventions. So, and as a general concept, you can't sort of protect an idea under intellectual property, but patents are probably the closest thing that you can get to that. It sort of protects something that's novel, that's unique, that's new, that you've invented. And the good thing about a patent is it gives you exclusivity. So for about 20 years in the UK, no one can do something that infringes your patent, i.e. does something that's quite similar to that. And patents can be anything from products like, a mousetrap you could patent, or a compound like a drug, or some type of manufacturing process. All of these things can be patented. Copyrights, as I was saying before, on the other hand, you don't need to register. It just comes into existence as soon as you create it. But with a copyright, sort of like a patent, you can't copyright an idea. So a lot of the ideas that have gone up on the ideas wall, that concept you can't protect. What you can protect, though, is the expression of that. So if you've written a long document that explains what your idea is or your concept, it's possible that copyright may subsist in that. and then you can be protected if someone else tries to copy that. And the easiest way to sort of, I guess, understand that is, I mean, a lot of you will have either seen the movie The Da Vinci Code or read the book, you know, Holy Blood, Holy Grail. And there was a case about that where the authors of the book had said Dan Brown had copied their idea effectively. And what the court said was, well, okay, while the idea is really similar, you can't protect that. And when we look at the actual, you know, his book versus their book, there's not enough of a copy for it to be an infringement. So that's a pretty sort of tangible example of what the law does, in that it says, look, a lot of people can have the same idea, and that's fine, but what you can't have is the same sort of expression of that idea. And the last intellectual property right I just wanted to touch on was trademarks, because this is going to be really important for you guys. You put a lot of thought into what your company's name is, what your products are called, and your logos and your designs and things like that. When you're doing that, you need to bear in mind that you can't trademark things that are descriptive. So if I was, I don't know, a manufacturer of bread and I wanted to put out a new type of loaf, I couldn't call it bread and think I could get a trademark for that, because that just describes what the product is. Because obviously, if I did that, then every other baker in the world, you know, would have a lot of trouble marketing what they were selling. But you could use that. Let's say you were creating a new computer or a new mobile phone, and you wanted your brand to be Bread Mobile Phones. It's more likely you could do that because your name or your trademark doesn't describe the product that it's attaching to. So you do need to think about that, and also be cognizant of the fact that trademarks not only registered in different jurisdictions, but also by class. So you want to know the types of goods and services that are going to be relevant to you. Initially, it might just be, you know, software and website related services. But if you think down the line, you might merchandise into, you know, t-shirts and other things like that. You might want your trademark to be able to apply to clothing and other classes. IP rights and startups. As I said before, this is just to really reinforce that the vast majority of your value as a startup is going to be in your intellectual property, and you need to be able to identify it to be able to protect it and then really commercialise it. And there are a lot of ways in which you can commercialise your intellectual property. The first thing I would say, though, is that you generally need to own your IP to be able to commercialise it or have an exclusive licence, because that's going to sort of keep that unique feature alive with you. The thing to be aware of is joint ownership. You may be collaborating with another co-founder or some other sort of business partners, or even just your friends, trying to come up with good ideas and putting them into place. It is possible to have joint ownership of most forms of intellectual property, patents and copyright. The one thing that people forget is that if you're a joint owner of intellectual property, you generally, absent some type of agreement between the owners, you can't do and exploit that intellectual property without the consent of the other person. So let's say Mark and I created something, a piece of software. I decided, you know what, I wanted this to be a cloud-based service and I want to go live in this type of way, and I wanted to commercialise the software in that way, but Mark didn't agree to that. I couldn't use the software in that way unless I had the consent of everyone. So be careful when you're creating things, and if you are creating sort of joint intellectual property, be really clear about who owns it, or if you're jointly owning it, you can make clear that each party can do with it effectively what they want, as if they were the sole owner. As I was saying earlier, intellectual property is like property, tangible property in a way, in that you can commercialise it, you can buy it, you can sell it, and you can get security over it. So for example, you know, you can spin out your company or the intellectual property rights in your company and put it into a separate entity, create a sort of special purpose vehicle for that, and either sell shares to that company or get some debt funding in relation to that, where maybe the royalty streams for that company is the collateral for the money that you're getting. I've talked a little bit about joint ownership of IP. The only other sort of main point I wanted to make about this that you need to be conscious of is the starting point of intellectual property and who owns it in the UK is that whoever creates it generally will own it. So that's important, because if you get a consultant to do some work and create a design for you, or to write your brochure, they're going to own the intellectual property rights in that, unless you've said something differently in your contract, which is why agreements are important, because you'll often want to own something that you're paying for. The one exception to that is when you get big enough and you've maybe got some employees who create intellectual property or mainly copyright in the course of their employment, that copyright or that intellectual property is owned by the employer. So you don't really need to do anything else to ensure that you own the copyright. Where this becomes a bit hazy is if you're not running your startup full time and maybe you've got a day job, it's possible if you're sort of developing your ideas in your day job that actually, if that becomes some form of intellectual property right, whether it becomes a patent or a copyright, you may not own that even though you sort of created it. It may be owned by your employer. So you need to be quite careful about doing things during work time, or if you're employing people, making really clear what it is that they're doing for you and who's going to own the intellectual property that may be generated from that. As I mentioned before, IP is generally created and registered and protected on a geographical basis. So if you think you're going to have, you need to think about where your major markets are going to be. And a really good example of this is, Burger King in the UK and the US is really big, whereas if anyone else here is from Australia, you'll notice that there's no Burger King in Australia. It's called Hungry Jack's. And that's because when Burger King went to launch in Australia, they went to trademark the name, but there was a small burger shop in Adelaide, which is one of the capital cities of Australia, but it's not particularly big. But there was a burger shop there already that was called Burger King. So when the US Corp went to register the trademark, they couldn't because it was already in existence. So you do want to think pretty early on about sort of foreseeing where your major markets might be, and then thinking about whether it's worth putting in trademark registrations in all of those markets at that time. Talking about IP and talking about your inventions, I think this is a real tension for startups, because there's a real community of startups, and even just a lot of the things that some of the other speakers have said today in terms of workshopping your ideas and networking and things like that. That's really important, but at the same time, you need to be careful not to disclose certain things about your ideas, because that can potentially hamper your ability to register them as intellectual property rights in the future. So for things like patents or trade secrets, once sort of the fundamental aspects of what you're trying to protect, i.e. your invention or your idea, is out, it's very difficult, if not impossible, to get protection for that. So you need to think about who you're disclosing to, what you're disclosing to them, and whether or not you've got some type of confidentiality agreement in place or some type of non-disclosure agreement to try to protect your ideas as you're discussing them and sharing them. The last thing I'm going to talk about is some other sort of financial aspects about intellectual property rights. Mark touched on some tax relief that you can get. There are a couple of new things that are worth noting for startups. And the first one is called the patent box. You may have heard about it. It's been in the press a little bit recently because it talks about a reduced rate of company tax for organisations that have a revenue stream that's effectively based on an intellectual property right or a patent. So if you're commercialising it or you've incorporated your invention, which is patented, into your product, you can reduce your rate of company tax down to 10% for that type of revenue, which is quite a significant saving once you're up and running and generating revenue. And the other thing to note is that there are R&D, so research and development tax credits that are available. So if you're investing a lot of money in trying to develop new technology, it's possible that the amount of money you spend trying to do that can be a tax deduction. So, and it's at 225%. So if you spend £100 researching and developing something, you can actually reduce your taxable income by £225, which is a pretty big saving. The only caveat you need to understand about that is the research and development needs to be effectively for the greater good. You need to be trying to solve some broader technological or scientific problem. It can't just be to make more money for your own company. That's sort of the end of the substantive content for both Mark and I's presentation. I guess sort of the takeaway message is these are all issues, whether you're starting a business and putting the corporate structures in place, or you've got ideas and concepts and you know you're going to generate intellectual property. But the main thing is you need to think about these things right from the start, because that can not only help you protect them in the long run and ensure that you're sort of legally compliant when you're running a business, but it can also reduce your costs down the line, because it's always easy to do things right from the beginning than to get to a certain point, realise that maybe you want to open a business in China, but the domain names or the trademarks of your business have already been taken and you need to pay a cyber squatter or someone to get them back. Whereas if you invested the money and think about these things right from the beginning, you can potentially save quite a lot of money down the line. So thank you very much. If anyone has any questions for Mark or I, feel free to call out.